attendees are coming in.
Am I ready?
A couple more minutes.
Can they hear me? Well, good morning, everyone. Good morning, Oregon Realtors. Thank you for joining us this morning. Typically, we look at the state of Florida and we are very envious. Good morning, everyone. Good morning, Oregon Realtors. Hang on, we have a little delayed tech issue here. One moment, please. Okay, we're going to try this again. Good morning, Oregon Realtors. Thank you for joining us this beautiful, well, not so beautiful here, Friday morning. As frequently, we are very envious of those who live in Florida because they have beautiful beaches, they have gorgeous resorts, and it's just a great place to get away. Now, however, right now, they are currently the victims of an insurance shakedown, as I like to call it. And over the last 5 or 6 years, you've heard about website accessibility issues. Well, the Florida Realtors, your colleagues there, are beginning to feel the wrath of an overzealous attorney and law firm. So today we are very fortunate to have, and excuse me with my glasses while I introduce Joanna. We are very fortunate to have Joanna Watkins with us today. Joanna is a native of Pensacola, Florida. She's a graduate of Florida A&M University and Florida State College of Law. Joanna began a career in law as an attorney for the Orange County, Florida Public Defender's Office, but discovered a love for the real estate industry after joining the Florida Division of Real Estate as a senior attorney. Over the next 16 years, she went on to serve as chief attorney and deputy director of the agency before an appointment by Florida Governor Rick Scott to director for nearly 7 years. Joanna has worked for Florida Realtors as senior counsel, interim director for executive offices, and associate general counsel. Presently, Joanna serves as vice president of law and policy and general counsel for Florida Realtors. She is absolutely wonderful. And a little tidbit about Joanna: she's an incredible singer. I told her I'll have to bring her out for a Oregon Realtor meeting and entertain you all. So, Joanna, tell us what's happening with the website accessibility issue in your neck of the woods, and welcome. Thank you for joining us today. Got to unmute. Hang on, Joanna.
There we go.
There you go. Okay.
I have the hang of this by now. Good morning, everyone. Thank you so much for having me today. Yes, I would like to share with you the horror story that I have been living, that our members have been living the last few weeks, and then share with you the light at the end of the tunnel. About 6 weeks ago now, I had a phone call and an email from a member late on a Friday afternoon. And she shared with me a copy of a document that she had received from a law firm here in Florida. And it was accusing her of violating the Fair Housing Act. And at the heart of the allegations was, according to this allegation, the fact that her website was not accessible to people with disabilities. And so that was the first time I had heard about this issue. That was Friday afternoon. By Monday morning, my inbox was full. My voicemail was full because it turns out that this attorney was blanketing the state of Florida with these demand letters and draft copies of lawsuits to our members about this ADA, or excuse me, website accessibility issue. But instead of alleging violations of the Americans with Disabilities Act, she was alleging violations of the Fair Housing Act. So that's kind of what we've been dealing with. And so I'm going to talk to you today about both fair housing and the Americans with Disabilities Act as it relates to website accessibility. All right, so I'm going to share my screen. Gotten pretty good at this here, so let me get started here. All right. So the Fair Housing Act, as realtors, we obviously celebrate, embrace, support fair housing. It's a part of our code of ethics. And so we get the idea of fair housing. And, you know, just this is kind of the classic picture in support of fair housing. I took this from the NAR site. We get it in our realtor world. Just quick review: Fair Housing Act, 1968 Civil Rights Act gave us the first set of protected classes. We've heard a lot about race recently with the Long Island, New York story that we heard. Color, religion, national origin. In 1974, they added sex. And then in 1988, they added handicap, which we also here referred to as disability and familial status. Now, the first picture I showed you is what people tend to think of when we think about fair housing. But for purposes of what we're going to talk about today, this is the picture that we should remember as it relates to fair housing, disability, and various types of disabilities. Not just wheelchairs, but also things like blindness and hearing impairment. Some of the things that we don't typically think of when we talk about the Fair Housing Act. But this is at the heart of these demand letters that our members started receiving, whether or not their websites could be used by people who cover the spectrum of the images that you have on your screen right now. So in thinking about fair housing, most people think, oh, well, you know, it deals with denying someone the right to access housing. That is true. But what we want you to think about when it comes to this website accessibility issue and the Fair Housing Act, and what is at the heart of this Portel Law Group's allegation about website accessibility, is the denial or limiting of services as a part of the real estate transaction, right? So it's not, she's not saying that the Florida realtors denied someone housing. Her allegations deal with the denial or limiting of services as a part of the transaction. And so think about the fact that we hear a lot about how the average buyer will walk into your offices having already searched the internet for the properties that they're interested in. That's that availability of information, readily available information to these buyers, is a service that many of our realtor members provide to the public in hopes that that buyer will become interested in that listing information that's available on the web. And so Ms. Portel, this attorney who sent these letters to our members, alleged that this is a denial or limitation of services for people who are not, who are disabled in some way, who are handicapped in some way. So that's the heart of the issue here.
Clever theory.
I'm sorry?
Very clever theory.
Exactly. And so not just clever, but also a novel issue, completely novel. Yeah. So when we got these demand letters, of course, we started researching this issue because we wanted to know legally where our members stood. And I have to tell you, there is no case law in the United States that deals with the issue of fair housing and website accessibility. So that's what made this very difficult to analyze, because there's tons of case law out there that talks about web accessibility with the ADA. Very little case law, or none actually, that deals with fair housing. So let's talk a little bit more specifically about these demand letters. So here's kind of how this works. The member gets the demand letter. They also get a copy of the draft complaint. Jennifer Portel is the attorney who sends this information. She is an attorney who is licensed to practice here in Florida. She, however, is sending this information from a law firm address in Washington, D.C. She alleges that she works with a group called Access for All. She says that they are a disability rights group that is harmed in some way by the fact that our members have websites with all of this fantastic listing information, publicly facing information about real estate, but that people with disabilities can't consume that information in the same way that a typically able person can. And so what we started to understand about this whole situation is, first of all, Jennifer Portell had not filed a single lawsuit, okay? These were just demand letters and draft complaints of lawsuits, but none actually filed. We also came to learn that Jennifer Portell herself had not filed any lawsuits in federal court for anything. So that tells you a lot, because you want to know your opponent when you're dealing with litigation. You want to know who is on the other side. And so we realized that while she is perfectly capable of filing these lawsuits, she has a Florida bar number. She had not yet filed any. What we also learned was that Jennifer Portell had initially turned her sights on the mortgage loan origination industry. She started sending these demand letters and these complaints to mortgage loan originators in California and Florida in early 2020, before she started sending them to realtors. So for whatever reason, she decided not to pursue realtors in California. But after she finished with mortgage loan originators, she turned her sights to realtors in Florida.
Hey, Joanna, how successful was she in collecting from the mortgage folks?
We're not sure, only because they don't tend to have the same type of kind of organized, I suppose, group that we do. So we weren't really successful in finding that out. We do know that there's an attorney in California, a law firm in California, with some information on their website where they at least cite the fact that they felt that they were very successful at pushing back on her in California. So if you take their word for it, she wasn't very successful in California. But again, that's the law firm's perspective. We don't have any evidence that one way or the other to say how successful she was in California. In Florida, again, we're not quite sure how successful she was with them. We have a number of members who are both mortgage loan originators and realtors. And so we gained a lot of insight early on by communicating with those members. The ones that we spoke to did not settle with her, but ultimately some may have.
Mm-hmm.
So in moving on and turning her sights to our members, we wanted to understand exactly what her approach was. And so this is how she usually works. She sends the demand letter. She will call you constantly. And actually she has a group of what we think may be paralegals. It's kind of a call center approach. They harass members relentlessly.
Wow.
And the goal is to set up conference calls with members. She does not work alone. She has a number of lawyers who work with her to cover these settlement conferences, these conference calls. And she, in her demand letter, she is asking for two things. She's asking for compliance with the law, and she's asking for attorney's fees. And so when you set up the conference call, she'll usually start off asking for somewhere in the neighborhood of about $5,000 in attorney's fees. Fast forward about 6 weeks later, she was settling for somewhere in the neighborhood of $1,000 in attorney's fees. So she rapidly started diminishing the amount of settlement that she was willing to take. So the thing about it is a cash grab for sure. And once she makes enough money, she'll move on. But we also were able to gain a lot of intelligence on it because we run a hotline for our members. And in talking to the hotline, the members on the hotline, we learned that a part of her settlement was that she would only go away for 9 months. She wasn't willing to go away forever. So even those members who considered settling with her, she would only agree to the 9-month settlement. So
Do you know how many of your members actually settled before you could provide assistance?
very few, if I had to guess. We don't have a specific number, but I'd say very few. Most members felt more inclined to ignore the demands. We do know that some, through their E&O carrier, settled the claims or expressed a willingness to settle because ultimately it was cheaper to pay the $1,000, let's say, deductible for the E&O carrier than it was to hire a lawyer or to fight the issue.
Which is precisely her strategy.
Exactly.
Yeah.
Cash grab. So that's the way this works. Now, here's the thing about the Portel Law Group. And here's the thing about web accessibility. We can't miss the forest for the trees. We cannot find the tactics of a particular lawyer so distasteful that we lump all of these suits into the frivolous box automatically, okay? Because while some may be, and while some tactics may be distasteful, web accessibility is an issue that as an industry, we really should start to take a look at, okay? Because while Ms. Portel has not filed lawsuits, there are many, many attorneys who have. So let's talk about accessibility for a bit. Accessibility is generally covered under federal and state law. Portel raised it as a fair housing issue, but certainly there is no shortage of cases being litigated every day in federal court under the Americans with Disabilities Act. Both address this issue of discrimination on the basis of disability. The Americans with Disabilities Act would prohibit discrimination for a place of public accommodation. And we're going to talk a little bit about how some courts have looked at the issue of whether a website is considered a place of public accommodation. These lawsuits are on the rise. So again, even if as an industry, and we're going to talk about some of the steps as an industry we have taken to address this specific issue, but if it went away tomorrow, this specific issue, if she decides to not move on to Oregon or California or any other state for real estate, the issue of accessibility for your websites remains. This is a chart that explains kind of the rise of ADA website accessibility lawsuits, okay? Same website, it's just a matter of an attorney arguing it from an ADA perspective as opposed to fair housing the way the Portel does. Not that we are conceding by any stretch of the imagination that in all instances, ADA is being violated by our websites, but I want you to understand the risk that is out there and the allegations that are being made. So in 2017, in the federal court systems, all federal courts throughout the country, there were 814 website accessibility lawsuits. By 2018, 2,258. Fast forward 1 year, more than 11,000 of these lawsuits. Here in Florida, we are particularly exposed. We are second. New York still leads the nation in these claims, but Florida is certainly second. Now, when I teach this to my members, I say to them, while we find the tactics of this most recent threat distasteful, okay, and I'll tell you specifically why I say that towards the end of my presentation today, I have to remind them that there are testers here in Florida. I assure you, while I am not licensed to practice law in Oregon, I would be surprised if there are not testers in your federal circuit that file these complaints regularly. Ms. Portel has not filed one lawsuit. Ms. Lucius, who is a tester here in Florida, has filed more than 250 of these cases in the last 2 years. These are filed lawsuits, not demand letters. And Ms. Lucius has filed ADA website accessibility lawsuits against some of the biggest names you can imagine. If you have eaten there, slept there, been entertained there, or worn their brand, she has sued them. Claire's, Hungry Howie's, AutoZone, Battery Plus, Ralph Lauren, Dooney and Burke, Beef O'Brady's, Joann's Stores, Rack Room Shoes, Exxon Speedway. She has sued them in federal court. Okay. And this, you have to understand, this is what breeds these types of lawsuits, because these folks settle. They call them nuisance lawsuits. Okay. These big companies kind of factor into their budgets payments to these attorneys and these testers to go away. And so when other attorneys see how successful this effort can be, it becomes quite a motivation to set up a similar enterprise. And so this is why I say that even if Ms. Portel goes away tomorrow, there are still issues with web accessibility that as an industry, we must address. So then the member will inevitably say, well, Joanna, then what do I need to do? How do I fix my website? How do I make my website compliant? Well,
Can I ask you a question? I'm sorry to interrupt.
absolutely, no problem.
Why is she choosing FHA over ADA? What's the financial difference? What's the benefit for Portel versus the ADA, which clearly they can get some financial remuneration, right?
Yeah. So there are a couple of theories we have. We don't know, honestly. We don't have a specific answer for that, but there are a couple of theories. So number one, there is the belief, there is a fairly successful legal argument that when you sue someone over ADA compliance, if you are able to quickly bring your site into compliance, when the matter gets to court, the defendant can successfully argue mootness and a defense. And what that means is you can say, Judge, I move to dismiss this lawsuit because I have fixed everything on my website. So there's no longer a dispute here. There's no controversy because I have taken care of what they said was wrong. That is a fairly well-tested theory under ADA, completely untested under fair housing, because again, remember, we have not had any trials or cases yet under fair housing.
What about the plaintiffs? What about the plaintiffs under the ADA that say the defense, the company says, hey, we're compliant now, dismiss the lawsuit. And then the plaintiff turns around and says, yes, they're compliant, but here are the damages I suffered when they weren't compliant. So great, they're compliant, but they also should pay me. Is that theory valid? Do they collect?
It is potentially valid because the ADA does allow for attorney's fees, but it is a little less, it's a little less clear a path than it would have been under a more novel concept like fair housing.
Got it.
The other thing, Jenny, that we really think may have motivated her is there was an attorney in Florida, and you may have seen this referenced in the letter that we're going to talk about in just a bit, that NAR wrote. And it talks about an attorney here in Florida that brought a number of these claims under the ADA, who was sanctioned by a federal court. So it would seem as if there is a little less tolerance in the court system for ADA abuse claims. And I don't want to suggest that the federal courts are not encouraging people to file who are, legitimately harmed by ADA discrimination. But at least in that instance where the attorney was sanctioned by the court and by the bar for these ADA claims and the abuse, I think that may have had a bit of a deterrent effect on some attorneys who may have considered going that route.
That's encouraging.
Yeah. So how do you become compliant? If I'm telling you, you really should start working on your website, what should you do? Well, let me tell you, the law is not clear. Let me apologize to you in advance for the fact that I cannot tell you how to make your website compliant. I know. That's worse than the "it depends" answer that lawyers always give, but really that's true. And the reason I say it is because while the Department of Justice has routinely taken the position that websites are places of public accommodation and that they need to comply with the ADA, the problem is they started rulemaking years ago, and then there was an election, and then all federal rulemaking stopped. These rules were a part of that package, and unfortunately, the rules were never taken back up. So there is no legal definition of web accessibility compliance, none. Now, courts have routinely looked to the industry for compliance, and we'll talk about that in a minute. There is some industry guidance for what that is, but you can look to a number of sources for compliance. You can look to the industry. You can also look to the courts. Now, I'm going to tell you how we do it in Florida, how courts have looked at it in Florida. Can't give you legal advice, so don't know how Oregon does it. But when I'm talking to my members about it, they always say, well, Joanna, if you can't tell me what I need to comply with, how do I even know I need to comply? And so I tell them, let me walk you through a couple of cases, right? There have been, I told you that Ms. Lucia settles these claims. Well, there have been a number of companies that have fought back on some of these claims, in Florida at least. And so we know from reading those cases that it has not always gone well for these businesses who try to push back. So one of the earlier cases is GNC, the big vitamin company. We know from the GNC decision that, and I bolded it here, we know that in that case, GNC lost. The court found that there was evidence suggesting that the website was inaccessible. Mr. Gomez said that the website did not work for him, that he was denied the ability to fully enjoy the services of GNC's website the way that he would a physical store, and that they were discriminating against him in violation of the ADA. So that case, GNC lost on appeal. They decided that the website was a place of public accommodation. So remember, I told you the ADA deals with whether or not a website is a place of public accommodation. In Florida, at least, GNC said, yes, place of public accommodation. So then we look, now that we know, okay, there are at least some courts in Florida that says it is a place of public accommodation, so the ADA is triggered. Then we have to look and say, so now what? Okay, we get to court, so what happens now that we know that it's a place of public accommodation according to Florida courts? The Dunkin' Donuts case shows us an instance where Dunkin' Donuts was very successful at the trial court level. They fought, and they were successful in front of the judge of getting the case dismissed. Judge, listen, we shouldn't be in court over this. We moved to dismiss this case. This is not an issue before the court. Court said, okay, great, you're right. We dismiss this claim against you. Mr. Haynes appealed, and the district court said, absolutely, Mr. Haynes, your case, you get your day in court. These are matters properly addressed during the trial court in front of a judge or jury. They reversed the appeal. Sorry, Dunkin' Donuts, Mr. Haynes gets his day in court. So it has to proceed. Can't just cut it off, right? So we now know it's a place of public accommodation. The ADA is triggered, has to go before a trial court for the trial court to decide this issue. And then one of two, what we call kind of landmark cases in ADA accessibility. One is here in Florida, the other's in California. Talk about Florida first. Gill versus Winn-Dixie. This was the first case to actually go to trial on website accessibility under the ADA. Again, still not fair housing, don't know that, but under the ADA. Winn-Dixie was sued by Mr. Gill. Mr. Gill said, listen, I cannot access information on Winn-Dixie's website the way that a typically able person can. I can't order a prescription. I can't use coupons. I can't do any of that stuff that someone else can. And so Winn-Dixie is discriminating against me. And Mr. Gill went to court. And this was the case that finally went to a full trial. The court ruled in favor of the plaintiff, that means Mr. Gill. So Winn-Dixie lost. This case is presently on appeal. One of the first things we did when we started getting these demand letters, we reached out to an attorney who's involved in this case because we wanted to get her insights on the reasoning behind the court in the Winn-Dixie case. We wanted to understand this web accessibility issue. And so we are following this trial, this case, everybody in Florida, quite frankly, many people across the country are, because we want to see how the court rules. This case could end up in the Supreme Court, and we would welcome it in the sense that it might give us some clarity on this issue. But so stay tuned on the Winn-Dixie case. But now one that did actually make it to the Supreme Court, this is the second landmark case, Domino's Pizza. Domino's Pizza is in your neck of the woods. So it's in your circuit. The thing about that is then it has much more of a bearing, obviously, on you and your websites than Winn-Dixie will. And so in this instance, this case reached the Supreme Court after having gone through the circuit courts in California. Initially, Mr. Robles sued Domino's because of ADA violation, because the allegation was that Domino's website and mobile app, okay, that's the other area you need to be concerned with, did not give him the same experience that the brick and mortar store did. He couldn't order food through the mobile app the way that he could if he was typically able. And so the case went up on appeal, ultimately reached the Supreme Court. Supreme Court in October of last year sent this case back down and said it needs to go to trial. It needs to advance through the process. So everybody is watching this case. Don't know what the current status is, but basically the important thing about this case was Domino's made some of the same kind of allegations, arguments that we hear our members make. There is no clear guidance under the law. How can we be breaking a law if we don't even know what the law says? And besides that, he's asking about, or he's claiming violations of a law, the ADA, that was written before the internet was even in existence. So how can we be breaking that law? So this is why that's a very important case, and we'll have to see how that goes. Now, not a lot of good news for you there, right? From a legal perspective.
Joanna, so is there, okay, that's a valid theory, but as Congress, has there not been any legislative change or request or submission or something to get the ADA in compliance with current day commerce?
So not lately. The last effort was the rule that was promulgated or proposed in 2013 that came to a halt. And it's interesting because we have worked with NAR on this hand in hand since this all started, because we'll get into this in just a second. But one of the things you should know is that Ms. Portell is not just pursuing Florida now, she's also pursuing other states. And so this is definitely not a Florida issue. It is an NAR, it is a national realtor issue. And so we also work with NAR public policy on this to emphasize the need for clarity, right? We can follow the rules if you just give them to us. And so we've emphasized that. And we found a letter that Senator Grassley wrote to HUD and some of his colleagues. And it's interesting because had I written a letter about my frustration about the lack of clarity under the law, it would have read exactly like Senator Grassley's letter. So there is certainly not a lack of consciousness in DC on the need for clarity for these claims. He actually talks in that letter about the frivolous lawsuits that come about as a result of the lack of clarity and how attorneys exploit that for these types of shakedowns. But he didn't use those terms. That was me.
Yeah, I got it. The interesting part is that you would think
Senator Grassley would use the word shakedown, but that was
yeah, I got it. But the interesting part is this impacts every potential business and industry, as we've already
absolutely.
by the lawsuit. So it's not just realtors crying foul. I mean, this is everybody needs clarity.
Yes, absolutely. So when you look at the lady that we talked to, the attorney on the Winn-Dixie case, she filed something called, we call it an amicus brief, right? So it's you know, you are impacted by the issue or the outcome of the case. And so you may not be one of the parties, but you are directly impacted by the decision. And so when you look at that docket, I think there were over 30 amicus briefs filed on this issue, because when you think about it, all these major retailers, think about the list I showed you for the tester here in Florida, they are all impacted by the decision in the Domino's case or the Winn-Dixie case. Every single retailer, and at this point now, right, service provider you can think of will be impacted. So absolutely.
So before you move further, one of the questions from one of our members, which is a good one, I know you've addressed it in your letters, is was there an actual plaintiff? I know she cites Access for All, but who was really impacted by one of your members' websites? Did she have someone?
Not seen evidence of an actual plaintiff. And this is the interesting thing, you know, so I mentioned that she does a demand letter and a draft complaint. Well, the thing about the draft complaint is it's scary enough to read that it causes our members concern, but because it's a draft, it's not really compliant with like the rules of court or the law required to pass muster for filing purposes. It's just really scary to a non-lawyer. And so she adds that kind of to bolster her position to the member. But the reality is there is no, when you read like Miss Lucius, the other one I was talking about, she is identified. She's the plaintiff. It says who she is. But that's because it's an actual lawsuit. Here, because she only sends a draft complaint, she has not yet identified who the tester is or who has actually suffered any harm. And so that opened up a lot of discussion about the legitimacy of the tester approach in fair housing claims. It would be really easy for her to correct that. She could already have a tester. She could name a tester before she files the lawsuit. I don't know that she doesn't have one, but she certainly has not given us any indication that she does.
And you're right. I think the fear factor is what gets folks like our members and other industry defendants, respondents to pay up and get out.
Yeah. Yeah. So they say she sent me a lawsuit. No, she didn't send you a lawsuit. She sent you a draft complaint.
Yeah.
But it looks enough like a lawsuit that in the member's mind, that's exactly what it is.
Right. Right.
Yeah.
Okay.
So we've been talking about this issue as an industry for years. We went back and we saw that we first started talking about it in our legal updates back in 2015, 2016. And so we realized, though, that it was not enough to just say, go make your websites compliant because the law said so. We weren't talking about the technology part of it. So I want to talk for just a minute here about the tech speak. Although, let me just say, I know just enough about this to be dangerous. Not at all tech inclined. I know this picture here is called code because I have a 17-year-old daughter and a 13-year-old son, but that's really all I know about it. But in order to address this for our members, I had to learn something about it, because one of the things we encourage them to do, and one of the things I encourage you to do, is have a discussion with your web administrator now, not after you get a demand letter, now, so that you're not panicking and trying to bring your website into compliance or make it accessible immediately, talk to your web administrator after the session and have a discussion with them about compliance or web accessibility. Although the law doesn't help you, there is industry guidance. It's called the Web Content Accessibility Guidelines. Your web administrator will know it as WCAG. Now we are on WCAG 2.0, although they just developed something called WCAG 2.1. This is developed through the industry. It's kind of a think tank of industry experts. It is a shared standard, often recognized and referenced by courts in their decisions for how you bring a website into accessibility compliance. So this is the first step. Talk to your web administrator about WCAG compliance. Then understand your frame needs to comply, and so does your content. The frame is what you chose to build your website. It can be WordPress or Wix or some industry-specific format, foundation, if you will, for the building of your site. But the content, which changes all the time, has to be compliant. And I'll tell you what compliant means in just a minute, but keep in mind, content changes constantly on your site. One picture can change. So even if you had everything in compliance, if you change one picture, you will not be. So compliance has to be viewed as a journey, not a destination. It is not fixed. It is ever changing, evolving, and you have to have a process in place to constantly chase compliance. Just keep that in mind. So work that into your business process in whatever way you and your web administrator think it's appropriate. Now, we've had our website administrator, Florida Realtors website administrator, do a web video for our members. It was kind of a WebEx, and they presented some of the stuff that I'm going to talk to you about. But if you go to our webpage, it is public, so you can access it without going to password. And I encourage you, if you got an hour of your life and you don't have anything else to do, please feel free to watch it if you so choose. At the end, there's some industry tools that they were very comfortable recommending you use. And so I would defer to them, because I'm always afraid to suggest to people, go run your site through this place or that place, because I'm not all that experienced in this area. But that's why we brought them in, because they're really good. There are tools that you can use, like audit sites, that will help you audit your website to identify things that are not compliant with WCAG. And then you can use that kind of as a talking point or discussion point for you and your web administrator to start working on those areas that you need to work on.
So Juan, I'm sorry to interrupt. How much responsibility are the administrators taking? And I don't mean from a financial perspective, but as far as advising their clients, hey, your website, that's great. We're going to develop a new website for you, but in this format, it's not going to be compliant. So you really should do it like this. I know it's going to cost you X, but aren't they providing the guidance? Every administrator should understand that this is a big deal and be advising their clients, correct?
Correct. And what I've found in talking to members after they've talked to their web administrator is, while they are all familiar with it, some of them were really proactive in addressing it on the front end, like ours was with us, explaining the different levels of compliance, and from the engagement point, helping us understand what we should be doing and helping us pick the right level of compliance for us. But then some were not quite so proactive, and they just kind of took a more standard marketing approach. Here's the services that we offer. You pick what's best for you. And then, especially if it was one of the more nationally recognized, you pick the format you want in terms of the frame, and then you kind of populate content. So I think it just is like anything else. It depends on the personalization of the service and the professionalism of the web administrator.
Because it's interesting because it's similar to a buyer hiring an agent to help them find a home. You're hiring an expert to make sure you don't step in it. And it's the same thing here. Our members are hiring these administrators to get their websites up, and they should be compliant as part of the service that they hire them for, but it seems like it's not across the board standard.
It is not. It is not.
That's concerning.
You get what you pay for.
Yeah.
You need to have a conversation with these folks about the level of service that they're going to provide to you. And so these are just a few examples to help you understand the type of conversations you need to have. If someone, you have these beautiful sites, you have photographs, you have videos. If someone is visually impaired, they cannot see the photographs. So you would have something called alt text. If you are a frequent Facebook user, Twitter user, you've seen this already where you go to upload a picture and it has this alt text box under the bottom. That's what that is. That's why that's there, because it is allowing someone who's visually impaired to use something called a screen reader, so that when they get to that picture, it will say beautiful sunset in the backyard of the home, right? So they can't see that picture, but the alt text will explain to them what that is. So that's what we mean by accessibility. If I am hearing impaired, if I go to listen to your video, I should be able to read captions or see a transcript of that video to understand what's being said because I can't hear it. That's what we mean when we say someone who is hearing impaired or visually impaired should be able to digest, use the information on your website in the same way that a typically impaired or typically able person can. So that's kind of what we mean. And you'll hear more of that on the video if you go listen to it. If you use social media, they pretty much already have these tools available. So maybe what you do, instead of recording your own video and uploading it to your web page, maybe you have a YouTube page for your office that you send everybody to, because YouTube already provides captioning and Twitter already provides alt text. So think about how to use some of the services that are already available to you so that you can divert some of that content off of your page if your page is not accessible. The one thing I want all of you to consider doing at a minimum that you can do right now is you can put an accessibility statement on your web pages. And it's just at the bottom where you see, terms and conditions, copyright, all that stuff. Put a link there also for accessibility. I put an example here for our Florida Realtors accessibility statement. It has a phone number and an email. It basically just says we are committed to accessibility for people with disabilities, okay? And NAR statement, very similar, although they have the buttons to click to expand to give more information. They also have a contact NAR. The importance of that is, at a minimum, if someone is having difficulty accessing information on your page, you do not want to be in a position where you have to explain to a court that you don't even provide information for them to be able to contact you if they need assistance. Okay, think about it. When you register for a conference, they say, do you have special needs? If you go to a government office, they say, do you need hearing? Are you hearing impaired? Are you visually? Because they are going to help you to access the service that you need. Give the public the same information for your business, and train whoever takes those phone calls or gets those emails to make sure that they are prepared on how to answer those questions. Don't just send it to your receptionist unless you're going to teach him or her how to answer those questions, okay? So, because it may be a tester, but the point of the matter is give them the ability to be able to ask you to help them. that will at least help you. That's the first thing that you can do that's free and easy to do. All right. Now, enough already, right? Enough of this good. Why did Jenny have me come talk to you if all I'm going to do is preach to you about what you're not doing right with your website and not give you anything to help you? Okay, so I gave you a video. That's great, right? But my goodness, not only is my glass not half full, my glass is empty, right? So I get it. I know I've given you a lot of information, and you know, I've told you all of this stuff, and it's a lot to digest. I promise you, if you watch that video, will help you. Put the accessibility statement up there. There's stuff at the end of that video that's going to give you kind of practical step-by-step. This is what you do from a technology perspective, because I'm not good at that. But here's what I'm good at. I'm good at legal stuff. Fairly good. And when you got a legal problem, you fight legal with legal. Okay, so I'm gonna just speak real candidly for you. For weeks now, our members have not been too pleased with me because they're like, Joanna, these people are threatening to sue us. What are you doing, right? And here's the thing. These are individual legal actions against the members, not against Florida Realtors, right? I'm the lawyer for Florida Realtors. I can't represent 190,000 members of the Florida Realtors. But what I can do is coordinate with some folks and address this from an industry perspective. So for weeks now, I have been working with NAR. I've been working with Jenny. I've been working with my counterparts in other states, and we have been coordinating a strategy to address this as an industry. Because here's the thing, this is federal law. She does allege violations of the Florida Fair Housing Act as well. But for the most part, this is fair housing. This is NAR territory. And if it violates fair housing for Florida Realtors, it would also violate fair housing for every member of NAR, for all 1.4 million, right? And so we really needed to come up with a comprehensive approach. And so hot off the presses, as of August 19th, this is a letter from Katie Johnson to Jennifer Portel. This is kind of representative of the first step of what we are prepared as an industry to do on behalf of the 1.4 million members of Florida of NAR. We are prepared to basically push back and say, we do not buy into this issue of fair housing violations here. We do not agree that the Fair Housing Act supports your claim. I'm not going to go through all the details. This letter is public and available to you. And so I just want you to see kind of how we lay out our arguments. Fair Housing Act is not supported here. There are no Fair Housing Act violations as far as we are concerned. There is no evidence of accessibility barriers under the Fair Housing Act. We cite to her approach of the demand letters and the draft complaints that she alleges. And we basically say that you cite to the Florida Fair Housing Act claim and that it's frivolous. We also say to her that we have questions concerning access for all. Jenny asked me, well, who's the tester? We have some questions there. And we have some questions about the Portel Law Group and whether or not you are indeed following the professionalism requirements that are required by your license, Ms. Portel. So we have put her on notice that we have some major concerns about her allegations. And we look forward to hearing from her soon. If we do not, then we will take it to the next level. But just know that Florida Realtors, NAR, Oregon Realtors, we got your back, whether it's this session or this letter or anything else we have planned. We do not intend to take this lying down. So that's my presentation.
I love how Florida paves the way for the rest of us. See, that's the nice thing. You guys are the leader of litigation that help educate the rest of us. So one of the reasons I wanted you to present today was so our members, we can get in front of this. And the moment they get these sort of demand letters, we're on it. And it's great to hear that NAR is all in. And I know you, Florida and Massachusetts, how many members up in Massachusetts have received this letter?
I don't know, but in talking to Justin, he had a very similar experience where kind of late on a Friday, I think it was, and I think he was out of town, he said, and literally over the weekend, he was flooded with calls.
So if any of our members get a letter, don't call their company legal counsel and let us know ASAP so that we can get NAR up to speed that it's now traveled to the West Coast.
Absolutely.
So how much, just real quickly, how much, because it's an interesting to get your website compliant. I know it varies probably on the size of your website. Is it individual or is it brokerage? What does it cost to get your website compliant?
So it is very expensive to do it the right way. You know, compliance pretty much means that, and this is in talking with our web administrator, compliance pretty much means that every aspect of your website is 100% accessible to someone with a disability. And so to do that, you don't just rely on technology, you rely on people, right? I mentioned the photograph and the captioning of the photograph, and I said, you know, a beautiful sunset on the backyard of the house. Let's say someone was rushing and they put into that picture a beautiful kitchen with cherry cabinets. That's not compliant. There's a caption there, but it's wrong. And an automated scan would not pick up on that. So true compliance means that you have both automated and people resources monitoring your site. That is a very, very expensive proposition.
Oh,
I have also seen folks make the effort to add, there's a very popular, and I'm not endorsing anything in particular, but there's a very popular widget that people add to their website. It is accessible to you for a requested $10 donation from a nonprofit. Requested $10 donation. You don't even have to give the $10 if you don't want to. This widget is so popular, the school district here in Orange County uses this widget to comply with accessibility requirements. So, you know, you gotta think, if a school district is using this widget, can't be all that bad, right? So my point is, you gotta do something. And if a $10 widget is what a school district is doing, then I think not doing anything is a real dangerous place to be. So at least the widget, at least the accessibility, you know. And recently I saw an ad for some real estate specific product that's like $49 a month, a service. So again, I'm not condoning or endorsing any particular service, but there's a lot of diversity in terms of the amount that you can spend as a business to try to start down the road of accessibility.
So a couple last questions. Were the demand letters to individual members or companies or both?
Great question. Completely random. So we had the first agent I heard from, the first broker I heard from, one of her agents got the letter, and she's a member of a large franchise. And so I thought it might be easily addressed, because of course I said to her, you definitely need to escalate this to your corporate counsel, right? Because if one of your agents, if they are a franchise where they provide the website frames to their agents. So my thought was, then you definitely need to let your corporate counsel know, because that means all of your franchises are potentially exposed, right? So the general counsels for the franchises are all on this as well. We've been communicating with them, so that's been helpful. But completely random. Agents, and by agents, I mean sales associates, brokers, sole proprietor brokers, large franchise brokers, brokers with small agents, brokers with thousands of agents. We have even had 3 of our local realtor associations receive demand letters.
Wow. It's interesting because you'd think she would be really strategic and go for the ones that aren't backed by the large franchise, corporate financial support. Easier to get a few $1,000 out of a single broker or interesting. So one of our members asked, can this ADA issue apply to marketing emails that have photos or charts?
Potentially, right? So that's been part of our discussion on the law here. Like, where do you draw the line? And this is the difficulty, especially with the fair housing part of it. Like, there has to be a line somewhere. You know, one of the attorneys in my office, every time we kind of play devil's advocate with this issue, you know, she always says, then do I need to make my yard signs Braille, right? Like, obviously the person who is visually impaired driving by my listing can't see my yard sign. And I'm certainly not trying to give any plaintiff's counsel an idea here, but the reality is a court really going to say that you have to make a yard sign, you have to add Braille to a yard sign, right? At some point, there has to be a line or clarity given to us.
Yes.
Federal government.
Yeah.
So, and quite frankly, I think we have to continue down both paths. We have to advocate for clarity, but we also have to continue to monitor these cases and try to find favorable decisions where we can to push back legally, fight law with law. The other thing I will say, because it's important, because our members were really upset by the tactics. You know, I came up with this fight law with law because we have to be careful, because there is a provision in the Florida Fair Housing Act and the Federal Fair Housing Act that prohibits retaliation for someone who either exercises their rights under fair housing or encourages someone else to. And so I wanted our members to understand we will respond, but we have to respond in a way that is legal and compliant. And so that's why we have taken the path that we have.
It's just, well, thank you, Joanna. I know we're out of time, but this is tricky, right? It's really because you want our members to be proactive and protect themselves, but we don't really have much guidance to give them on how to exactly to do that. It's tough.
Absolutely.
It's tough. So, all right, well, we'll just stay tuned and we'll be following your lead and looking to you for some guidance to continue to provide to our Oregon realtors here as well. So thank you, Joanna. At least you can go to the beach today if it's safe. Put on your mask and head out to the beach there.
I'm going to work on my flower bed, Jenny. But
All right.
Watch the video, Jenny. It'll be very helpful.
Very good. Thank you, Joanna. Thank you for spending an hour with us here in Oregon. Have a great
My
weekend.
pleasure.
Okay.
Bye-bye, y'all.
Take care.